Our next case is Dobias versus Hepp. Each party will have 15 minutes to present their arguments. Since you're the only person arguing today, there will be no rebuttal time for you, just the regular 15 minutes. The arguments are being recorded. When you present your argument, please introduce yourself. Keep your voice up so the recording can pick you up and stay behind the podium so we can also keep you there visually as well on the recording. I don't know what would be necessary in this case, but you should not use the name of a child, minor, or victim. If you were to do so, please use initials or some other designation. With that, we've read your brief and are ready to proceed whenever you are.
Great, thank you very much. I'll try not to rebut myself today. My name is Brent English. I represent John Hepp, who is the appellant, and I believe the opposing party is pronounced Dobias.
Dobias, thank you.
Thank you very much. I understand that the issues in this case are really quite simple and straightforward. I think it is important to lay out the facts, even though they are articulated in my brief, I think, quite accurately and simply. 2013, the parties were divorced in Lorain County. A child support order was imposed or ordered against my client for $800. He fell behind in 2017 and he owed about $25,000 in arrearages. Holly Dobias filed a motion to show cause. We have no issue with that at all. Service was perfected upon Mr. Hepp. Mr. Hepp appeared at the very first hearing in the case, pro se, and he agreed. He was in contempt. He agreed on the purge conditions for contempt, and he specified that he would transfer his interest in a Roth IRA to Holly Dobias to pay most of the arrearage, namely about $23,000, and he would pay the remainder of the arrearage by virtue of transferring another tax-deferred retirement account. In fact, that occurred, although it did not occur on the time frame that was specified in the magistrate's order that memorialized this agreement. There was no hearing, no issue, so it was merely filing the motion, him appearing, him acknowledging he was in contempt, him agreeing to resolve the matter, and then a resolution of the matter. 2 years later, Holly Dobias filed a motion for attorney's fees. Now it's clear under the law that if she properly provided evidence of attorney's fees, she could recover reasonable attorney's fees under the circumstances. At that point, when she filed her motion for attorney's fees through counsel, James Burla, he retained me to represent him in the case. Because we had many problems with the amount of attorney's fees, the number of entries, and the fee bill, which was not attached to the motion. So even though the local rule requires that you specify the basis either in an affidavit or in the motion for the attorney's fees that you want and how much, and customarily that's accomplished by a simple affidavit with a copy of a fee bill attached. It was not attached. So we had to obtain the fee bill. Then when we saw it, we had a lot of problems with it. So we sent a request for production of documents to Mr. Barilla to be answered by his client. And when that did not occur, when the response did not occur, we decided to send a notice of deposition to Mr. Barilla so that he could appear and explain his bill. And when we showed up for the deposition, Mr. Barilla did not appear. Ultimately, the matter was set for trial in front of Judge Glass, trial judge here in Lorain County. And we raised with the judge the fact that not only has our discovery not been responded to, but that Mr. Burla felt that he somehow was sui generis and did not have to appear because he thought he wasn't obligated to. That's obviously incorrect.
And all this is in the record, Mr.
Yes, oh yes. But nevertheless, instead of the judge continuing the case and ordering that the material be provided or many other remedies, she decided to proceed with the hearing on the merits. We have not assigned this as an error. We thought at some point, well, based upon the evidence that actually based upon what happened at the hearing, we thought it unnecessary to assert that assignment. I could rebut myself now, but I won't. Nevertheless, when we got to the so-called evidence, Mr. Burla, for some inexplicable reason, did not testify at all. He did not set forth his bill. He did not testify what he had done. He did not testify that it was reasonable. He did not testify at all. Instead, approximately 30 minutes before this hearing, apparently a gentleman named Mr. Fritz, who is a lawyer of some duration here in Lorain County, I believe he said 31 years, was asked to review the bill and testify via Zoom regarding the bill. We objected to that, but nevertheless, he testified. He said that he had reviewed the bill. There was nothing remarkable about the bill that he could see on its face. However, he had no knowledge whatsoever if any of the entries in the bill were accurate. He had no idea what Mr. Burla had done in the case. He had not spoken with Mr. Burla, and he had likewise not spoken with Holly Dobias, so he could only offer that the hourly rate was reasonable in his opinion, which was $200 an hour, but he could not testify about the other facts, which were, of course, highly relevant to whether or not the amount of the bill was reasonable under the circumstances. And then Mr. Burla called his client, who testified that she was able to testify that to each of the items that were set forth in the bill, that the amount of time that Mr. Burla had spent was reasonable and customary, and that she believed the bill was reasonable. However, on cross-examination, we inquired of her as to exactly what she knew. And in fact, we went through every item in the bill, which happens to be 35 items in the bill, on 35 entries of attorney's fees, and on no occasion, not one, did she have any idea what had been done, how long Mr. Burla may have spent working on the file. So therefore, she did not say whether it was reasonable or unreasonable, whether it was done or not done, or whether any service was rendered or not, because she had not even any recollection, but really no knowledge at all, because of course she wasn't there when Mr. Burla allegedly performed these services. Then he rested. We argued to the trial court that it's not very hard to prove an attorney's fee statement. There are customary, reasonable ways of doing it, but that this is not the proper way of doing it, that in fact there is no credible, competent evidence in this record probative of anything regarding attorney's fees in this case, and as a result, that motion should have been denied. Trial court took the matter under advisement. Mr. Brill moved to introduce his attorney's fee bill without authenticating it in any manner. We objected. He didn't testify that each and every item on the bill was performed at or about the time that the service was rendered, what he rendered. As I pointed out, that it is inexplicable that he, who had the only person who had knowledge of the facts, refused to testify. Nevertheless, the trial court admitted the bill over our objection, and then we appealed.
Counsel, the local rules provide in Lorain County that you don't need an expert to testify. Do you think that applies to the counsel that prepared the statement, or is that really pertaining to having an outside person come in?
It applies to an outside person coming in. You don't need to have a separate outside third-party expert to testify, but that doesn't mean you don't need to itself. The lawyer then would be in a position to establish what he or she did, the reasonableness of the service, the need for the service, the amount of time spent on the service, which are the conditions preceding to recovering attorney's fees. But clearly, if the local rule were to suggest that the lawyer himself or herself does not have to testify, then that raises a fundamental due process issue, particularly in this case.
And the trial court also said that she could review the bill herself and determine whether it was reasonable based on her experience. And she said that she thought it was reasonable here because of the contentious nature of the proceedings. So what about that the trial court says?
Well, first of all, it was hardly contentious, and that's why I pointed out to you the importance of history of the case. John Hepp came and admitted his contempt and agreed to pay the $25,000, and in fact paid the $25,000 based upon a single court appearance that was in front of a magistrate, and that was the end of it. So the idea that somehow there's a $5,640 bill that he subsequently has to pay, and the trial court's assumption, but frankly had no involvement whatsoever in the matter, because that was not, that's just not, it's not been, the record shows that there is nothing that Judge Glass was ever involved in this case whatsoever. But also that raises a fundamental question. I don't think a court can take judicial notice of its involvement in a case, assuming for a moment that it had that involvement, without at least hearing competent evidence, which is easy to present from the lawyer seeking the attorney's fees, or the party seeking the attorney's fees, if the party has knowledge. But under these circumstances, I believe that this is fundamentally erroneous for the trial court to have said, okay, notwithstanding none of the evidence that you have presented, I'm just going to award you $5,640, which then forces Mr. Hepp to have to come to the Court of Appeals to seek relief.
And you have about a minute and a half left, but let me ask you, after the contempt fine, and I know this was before you got involved in the case, were there a number of purge hearings where they were trying to work out this issue with the 401k or anything that occurred along the way, or was it simply a contempt case, then a motion for attorney's fees at the end?
There were purge hearings scheduled, but did not go forward. And this was because the magistrate's order indicated that you had a certain amount of time to pay this money. And the fact of the matter was, they had some complications in transit. They thought they had complications, but in fact the $23,000 was in Holly Dobias's possession at the time, all John Hepp had to do was sign off on it, which he readily did. And the remaining $2,300 he obtained from another account and paid it. But my point is that Mr. Barilla, if in fact there was a valid basis for attorney's fees on behalf of Holly Dobias, could have readily come and testified so that he could have established the reasonableness of the fees and what was done, and the things that I have pointed out from the case law in my brief are elementary in order to obtain attorney's fees. The fact that he didn't, this is a lawyer seeking attorney's fees on behalf of his client who refuses not only to provide discovery about his attorney's fees, but then at the time of the
Mr.
hearing.
I'll you're out of time, if you would briefly conclude, please.
Okay. Refuses to testify, so therefore I respectfully request that the trial court erred in this case, and that this case should be reversed and the request for attorney's fees should be denied. Thank you.
Thank you for your presentation today. We'll take the matter under advisement and issue a decision in due course. With the decision is released, will mail you by the clerk of courts and also available on the High Supreme Court website.